I'd rather, it's better for you to do that before the deposition as opposed to be confronted with any type of contradiction at your depo. The attorney is going to specifically ask you, let me backtrack a second. When you review those documents, okay, and review those answers, if there's any changes to those answers from the time that you provided those answers to your attorney to the time that you are reading them in preparation for your deposition, let your attorney know beforehand, because the attorney can make what is called make a supplemental, an amended answers and correct whatever mistakes were made or corrections or any type of addition that has to be made to that answer to the interrogatory. And I'd rather, it's better for you to do that before the deposition as opposed to be confronted with any type of contradiction at your depo. And that happens often. Sometimes people write in, and that's what they recall at the time. And then, when they're preparing for the depo, say, I remember, you know what, this particular answer is not exactly the way, it should have been written. And you told that to your attorney, and then your attorney can do an amendment to that particular interrogatory and submit it to opposing counsel. Of course, opposing counsel is going to ask you about that change, and that is fine. But you're better off coming forward with that change as opposed to having a confrontation or a challenge to that based on newly discovered evidence that was not available at the time. It's very common that when you provide your documents to your attorney, that some documents perhaps were not found at the time, you do not remember that they were available, or in some cases you don't think they were important. If there's email communication between you and the other side already has it. So review whatever you provided to your attorney and make sure that you provided everything that was asked for.